Hi everyone, I'm Dale Smith, aka Journo Dale, and we're here to talk about Canadian politics. All right, we're here with University of Waterloo's Emmett Macfarlane. First of all, he's got a book to plug. Emmett, why don't we start there?
Yeah, no, this is a new edited collection titled Disciplinary Divides in the Study of Law and Politics. And it's a collection of legal scholars and political scientists exploring the different ways we think about and look at and examine different legal issues. And the book covers a bunch of areas of constitutional law, like the Charter of Rights and federalism, to immigration law, elections, constitutional change, the relationship between courts and legislatures. So it's a great volume. It should be really of interest to any students interested in legal issues in this country, and excited that it's finally out.
Yeah. And I think that's a perfect way to talk about what we want to talk about this week, which is Danielle Smith's referendum on a referendum, because one of the things the way she's phrasing it is that as if there is a constitutional process that this can start. And my understanding is that there is no such thing as a constitutional process on a binding referendum on separation. So why don't we start there in terms of what we think this is supposed to be referring to and what the reality really is here.
Yeah, I think what she might be trying to refer to is the idea that the famous Supreme Court reference resecession of Quebec in 1998. The court ruled really two things. One is that provinces cannot effect unilateral secession, so provinces can't just succeed. There's a constitutional requirement for any major change, and that is the amending formula. The other thing the court famously decided was that there is a duty to negotiate upon the other partners of confederation if a clear majority of the voters of a province vote in favor of secession on a clear question. What the court said, though, is that the duty to negotiate is just that. Negotiations don't necessarily lead to secession. The courts won't have any say over how negotiations are conducted. These are all political matters. Even the question of whether a referendum resulted in a clear majority on a clear question is left entirely to the political actors to decide. And under our amending formula, that means the two houses of parliament and all of the provincial legislative assemblies. And so to say that a referendum creates a constitutional process just isn't accurate. If anything, the over the decades since the secession reference was decided, it's become more and more clear that secession probably just isn't practically possible in Canada. The honor of the Crown and the role of the treaties and Indigenous rights, given the state of the jurisprudence, given two recent lower court decisions in Alberta on these referenda processes in Alberta, It's quite clear now. It's hard to imagine how, even if a majority supported Alberta secession, how that could possibly happen in a constitutionally valid way. And so what we've seen from Premier Smith, I think, is very worrying, very, I think, deeply concerning effort to placate a separatist part of the UCP base. Mm-hmm. She has done everything to enable and to deepen the kind of existential tensions raised by secessionists in that province, all in the face of a situation where there's not really any huge support for secession. Every poll has had it from 20 to 25%. So she's playing a very dangerous game with national unity stakes. I think, there have been a lot of criticism, including from some conservative commentators, on how she has handled this. And it's really, honestly, in a way, it's quite disreputable of her, the way she has continuously framed this stuff. And now, of course, they're going to engage in this referendum on whether there should be a referendum absurdity.
Yeah.
So to speak of a constitutional process in that context is kind of to make a joke of the Constitution in a way.
Yeah, for sure. I'll make two observations there. One of them is that from a grassroots perspective, I have not heard one single person in this country say, if the UCP is worried about the separatists taking over, then ordinary people should buy memberships and drown them out. And I think that's an important thing that nobody has said. So I'm just gonna leave that there. The other thing is to go back to what you're saying about the treaties, and I think this is really something that I don't think enough people are quite understanding. Particularly because they didn't see that as being part of what happened in Quebec with the Clarity Act and any of this kind of stuff. But you've written pieces on this in terms of how the landscape has shifted, and we simply can't ignore this particular aspect of this debate, such as it is a debate.
Yeah, no, I mean, in the court. In 1998, the court recognized that there are Indigenous rights implications here. Indigenous peoples will need to be consulted, but they didn't elaborate on that.
Yeah.
And I think if a Supreme Court were to write basically another secession reference today, there would be a lot more attention to that. And in fact, the unwritten constitutional principle of the honor of the crown is something that developed after the secession reference. And the court has, in many landmark cases now, elaborated on the implications the honor of the crown has for how governments can conduct their business. And the stakes are all that more higher when you're talking about a secession that would have the practical effect of tearing asunder the treaties that actually apply to almost all of the territory of Alberta. A treaty process that was engaged before Alberta existed as a province.
Yeah.
These are part of the fabric of the Constitution. And some scholars, I think rightly, argue they are the foundation for the Canadian Constitution. They are part of what allows the kind of colonial Constitution Acts of 1867 and the associated documents to have legitimacy and to operate the way they do. And so to ignore those and to pretend that a secession process is possible, absent, all of the affected First Nations actually being on board with secession, it really becomes a bit of a constitutional non-starter.
Yeah, and I think this is, I guess underappreciated elements, and speaking as someone who comes from Alberta, I don't know that there is enough of an appreciation that this was their land, and the treaties were essentially how they agreed to share it, including the resources, and wound up getting a bad end of that deal in the long run. But there are certainly attitudes out there that see First Nations as more interlopers than the fact that it's their land.
Interlopers, or that Indigenous peoples are just a special interest group.
Yeah.
And even the perverse view that that these rights are somehow illegitimate, that they're getting special benefits or favors from government as opposed to generations of oppressive tactics and exclusion from society and having their way of life completely trampled on. And so, I mean, these are deeper questions that are, I think, tied up not only in questions of the Constitution and how that should be viewed, but the broader kind of polarization and culture wars that we see going on today, where there's now a big blowback against things like Indigenous rights and reconciliation entirely.
Yeah, and that kind of leads to my last point, which is Danielle Smith is now also wanting to open constitutional negotiations around Section 35 and seems to be indicating that the courts are going too far in asserting things like rights and title. And we're seeing this play out in BC around the Cowichan decision, and this moral panic more than anything around property rights supposedly being vaporized when that's not the case at all. But there's certainly this drumbeat going on trying to weaponize what's going on there, and I'm pretty sure this is part of what Danielle Smith is trying to play into, on top of the fact that the courts have twice now stymied a referendum process because of consultation. So I just wanted to kind of throw that in there, and I guess see. It would seem to me to be a non-starter, but yeah, what's your thought?
Yeah, I mean, this is again, there's a shamelessness to this proposal because it's so clearly designed to try to undermine Indigenous rights. Formal constitutional change in this country is generally a non-starter, regardless of the topic. This is any change to something like Section 35 affecting treaty and Aboriginal rights is the sort of change that would require at minimum what's called the general amending procedure. So you would need not only 7 provinces on board, but also the 2 houses of parliament to affect any changes. We already know that any constitutional change of that magnitude is going to be a non-starter for Quebec, which has consistently held that any constitutional reform must either include recognition of Quebec's distinctiveness or additional powers for Quebec.
Yeah.
And I imagine this will be a non-starter to most premiers and indeed the federal government as well, who aren't interested in weakening Indigenous rights. However inconvenient and challenging certain title decisions, certain duty to consult decisions under Section 35, and upholding Indigenous rights can be, I would like to think that most of the political class in this country is still committed to reconciliation, to upholding those rights. And I don't see, after decades of absolutely treating the Constitution as a Pandora's box when it comes to opening it up and making amendments, I don't see that climate changing just because Danielle Smith has decided to complain about it. Yeah. So on the one side, thankfully, that is probably a non-starter. But if Danielle Smith was wondering why First Nations are going to court and asserting their rights in the face of her efforts to get a secessionist referendum rolling, she might not look any further than the mirror, because this just reinforces why they don't trust her, why they see her as a threat to their rights, and why they're fighting to keep them.
Yeah, absolutely. All right. I think we're going to leave it there. Thanks so much for taking the time to do this, and we'll chat again in the near future.
Happy to do it. Thank you.
All right. Cheers.
And that's everything for this week. Join us again next week for some more Canadian politics. I'm Dale Smith. It's at journo_Dale on Twitter and journodale_no_ on Bluesky. And don't forget to like the video, share, subscribe, and support us on Patreon. Thanks, everyone.